Good morning, everybody. Welcome to Weber Gallagher University and Weber Gallagher's series of educational programs. And this is our workers' compensation series. My name is Jeff Newby, and I'm a partner in our Mount Laurel office. And I'm presenting today with my partner, Mark Sotaro, who used to be in the office next to me, but now he's a hoteler, so now he'll be occasionally next to me. We're presenting today in the Philadelphia office. And I just want to remind you, if you'd like to see this webinar again, share it with others or see our WG University programs, please visit the Weber Gallagher website at www.wglaw.com. And you'll find a copy of this presentation and others under the Weber Gallagher University page. And also feel free to contact the firm with any questions at wglaw.com. So today's presentation topic is controlling medical costs and the catastrophic claim. So let's get started talking about this topic. So what I wanted to start off in talking about is we broke it down into the various exposures that you have in catastrophic claims. And the first one that we're going to talk about is the medical expense piece of it. And as all of you out there that handle these type of claims know, the medical expense part of catastrophic claims is oftentimes the largest single exposure in a catastrophic claim. Especially in a case in a state like New Jersey, where you may have more control over the wage loss part of it. Medical expense is much more difficult to control for lots of reasons, and we'll talk about some of those. But the first thing we wanted to make clear to you guys and just remind you of is take advantage of Section 15 in the New Jersey statute. It's a unique part of the New Jersey statute as compared to our brethren, our bordering states between Pennsylvania, Delaware, and New York, where they don't get the control treatment through the life of the claim. In New Jersey, you get to control treatment from day one till the end of the claim. If it's accepted, it's compensable, and you can't avoid that part of the case, then control the treatment.
I think it's important to note, though, when Jeff says that control treatment, what we're talking about is actually authorizing the medical providers. You can't control what the providers are going to do, but you can make sure you have the appropriate medical providers to provide the treatment.
Sure, yeah, we can't tell them what to do. We don't tell them what to write or what studies or diagnostics to prescribe and things of that nature. But you want the injured worker to see doctors that you have chosen. You don't want to lose control by trying to doctor shop, sending to various doctors to get the opinion that you want to hear. In a catastrophic case, you already know that the injuries are significant. So you want to do your best for the injured worker and get them into the best possible shape that they can be in. So take advantage of the fact that they're supposed to see the doctors that you're choosing. So some of the obvious catastrophic claims that will come across your desk, you're going to know from day one that it's a catastrophic case. So to give you an example, we talked about somebody falling off of a roof. I have a case pending right now where the person fell off the top of the truck, and I've seen the video. From day one, you know it's a catastrophic case. A significant motor vehicle accident where the injuries are obvious, severe, from the emergency room records, the initial treatment records. You know from the beginning you're going to be dealing with a catastrophic case. It's not going to go away quickly. It's not soft tissue strains and sprains. But what Mark and I wanted to point out to you is sometimes the catastrophic case isn't as obvious as the initial records appear. So look for references to chronic regional pain syndrome, or CRPS, the old RSD, reflex sympathetic dystrophy. If you start to see references to that in OCMED records or panel doctor records, we prefer that they not make those references because oftentimes they're not experts in that field. I mean, the true experts are usually anesthesiologists, pain management specialists, neurologists. Those are the experts to diagnose that. So we prefer our OCMED docs not start throwing those phrases around, because when they start throwing that phrase and that acronym around, petitioner's counsel sees upon it from day one until the end of that case. Even if it's been subsequently eliminated as an appropriate diagnosis, they're still going to use that in every argument in chambers about the value of the case because their client had chronic regional pain.
Yeah, and that's probably one of the leading drivers of costs and claims is pain management. So when you start getting into complex pain, CRPS, and things like that, it leads into that pain management that's ongoing, and you never seem to cut it off.
So if you see this referenced in the medical records, you probably want to do a few things. One, you want to reach out to the doctor's office and ask them why they put that in the records, and if a referral is necessary to a true expert to determine whether or not they have that condition. Get that referral made quickly, because if in fact it is accurate, the best thing and the best treatment for CRPS and similar conditions is early diagnosis and treatment. You don't want it to drag on, because if it's a true and accurate condition, and it starts to affect the opposite limb, whether it's a foot, a hand, or an arm, you're going to be dealing with a significant case with medical bills out of control. So this is the type of catastrophic case you want to see at the outset, but it wouldn't necessarily be that obvious unless you're reading the medical records carefully. Another type of case that can become catastrophic are your spine cases, your cervical and lumbar injuries and surgeries. If they go well, you can usually tell soon after the surgery with the referrals for physical therapy, and they seem to be progressing, and the complaints are dissipating as you read the physical therapy and the doctor's records. But if you're not seeing that type of recovery, you're seeing ongoing complaints of radiating pain, numbness, tingling, things of that nature, that's when you want to make sure that the doctors are taking a hold of that case, making sure that there's appropriate follow-up care. If they need follow-up injections, they need follow-up injections. And if you need to involve a second opinion to determine if the treatment's appropriate, get that second opinion. But in a case like this, we always recommend hire the best expert. Don't look for your hired gun to simply try and close your case down. If the injured worker isn't recovering well from that surgery, you're going to be dealing with a huge case, big exposure. So get them to another spine expert, somebody that you would go to, you would have a family member or a friend go to. Because again, you want the best outcome, and you want to try and avoid these huge medical expenses in this catastrophic case.
Yeah, I was going to emphasize that as well, is to go for your second opinion. If a surgery is going to be recommended, and you think there might be an issue here as to whether it is really necessary, or is this the right doctor to perform this surgery, you may want to go for that second opinion to see what is best. Of course, you want the best outcome. That's going to be the best way to control your costs.
And another type of claim that may blow up on you, become catastrophic, are the concussions or psychiatric cases. Those are, for us on the defense side, they're so hard to defend because there's very few objective tests. With the concussions, we've gone to the presentations where neurologists are speaking to the Bar Association and the judges are in the audience, and the neurologist, unfortunately, sometimes that speaking is chosen by the petitioner's attorney to say, hey, will you speak to everybody for us? And they come up and say, you know what, sometimes the most minor of concussions lead to the most significant symptomatology, and they drag on forever and they don't recover. And you can't prove or disprove because the CAT scan of the brain, the MRI of the brain, they're going to all be negative. But don't be fooled. Minor injuries or seemingly minor concussions can be catastrophic. Well, then, of course, the significant injury is also to the brain or the head's catastrophic. So when I listen to some of these presentations, I'm like, well, then everything can be catastrophic, and the evidence to prove or disprove that it's a problem is very variable and vague. So you have to keep a close eye on these, and again, get the best neurologists to be treating these, and looking for consistency in the history, the physical findings, and examinations and diagnosis. And if you need a second opinion, you got to get a second opinion to see if whether or not the history of this case thus far makes sense.
Right. It's like, as Jeff said, the key is tests. There are tests. Most of your concussion and psychiatric issues are very subjective, but there are some objective tests that can be run by psychologists and other offices that can rule out things that somebody may be complaining about but are not real. So again, the proper expert is the most important thing.
Right, and that's the consistency part, because that's what they look for. They look for consistencies in presentation, history, symptoms, things of that nature. And I've had a couple of cases, I don't know about you, Mark, where there's not a whole lot of board-certified neuropsychologists. I think board-certified neuropsychiatrists are even fewer and farther between. They're usually either a neurologist or a psychiatrist, even though they're a sister board on their certification. They're one or the other. But I've had a few cases where board-certified neuropsychologists have been a huge help in concussion cases, right, because they are extremely thorough. They're half-day evaluations. With the history portion, they're very thorough in reviewing the medical records, and they do some very good testing, which has been helpful to me in trying to sift through what's legitimate and what's not. And that leads us to the other potential catastrophic cases, and then these are the psychiatric cases. Again, difficult to prove or disprove without being extremely careful and in analyzing the history, the symptoms, and doing your checkups, your surveillance, and Social media, are they saying that they're housebound and they can't be in public, et cetera, and they're extremely active and busy? The psychiatrist may not even be aware of how inconsistent they're being and disingenuous between history and what's actually going on.
Yeah.
So
it is very difficult, as you said, even with surveillance. How do you surveil a psychiatric issue? Unless it's somebody, like you said, that where they're claiming they're housebound and they can't do anything, and you get them doing things. But on the other hand, somebody with psychiatric issues can be going out and doing whatever. How do you pick that up on a video? It's tough, and finding the right doctor is also very tough from a psychiatric standpoint.
It is. Some of the other helpful surveillance that I've seen over the years, let's give a bank robbery case, for instance, PTSD, and they'll talk about their flashbacks and their nightmares, and they'll say, well, I can't go banking. I just can't go near a bank. It's got to all be online. And then surveillance shows them going in and out of banks. Something like that. That can be a big trigger. And if the psychiatrist has bought their history hook, line, and sinker, which oftentimes they develop this rapport, and they just they accept the version of events they're getting from their patient. And then if sometimes they're shown something that's completely inconsistent, that can change their treatment protocol and their prognosis. So these cases, concussion, psychiatric, they can become catastrophic. So really get your arms around them early. You have to be very thorough in your analysis and kind of just stay on top of them. That you can't let them kind of go their own path. You have to be involved as much as possible.
And I think we're going to be talking a lot more about our investigation, because you want to look into someone's background, especially in a psychiatric. Did they have treatment before? Go to family doctor records. You'll find that some people have been on psychiatric medications. They may have been on depression medications. So again, we'll get into a little about that a little bit more later, but that's key in a psychiatric claim. So
what we want to talk about next is, once the catastrophic claim has been identified, whether it was obvious or you're seeing it building, it's a snowball going down the hill. A couple of recommendations. One, choose the best possible experts. We've already touched on this, but just to follow up, in a cardiac case, in a heart attack, the concussion case, psychiatric, the spinal injuries, et cetera, you want the best possible experts. I try and recommend, and I think all of the attorneys in our office recommend to our clients, experts that we would want to see, a family member or friend would want to see to treat for this kind of condition, because that gives us that much more legitimacy in court. It gives our clients that much more credibility when I'm arguing a case in front of a judge and I say, Judge, we sent the person with this condition to Dr. X. And the judge looks at us and says, good call.
From a litigation standpoint, it's also key to knowing the judges know what vicinage you're in and who are the respected experts in that area. That's very important, because you could choose one doctor who you think is great, but a judge may like the opinions of another doctor. So you may want to go in that direction, because that's going to give you your best credible opinion and the more accepted opinion by your adversary and by the judge.
And I don't want to go too far afield on that topic, but those of you who handle New Jersey workers' compensation cases know how the respondents, the defense firms, work. We assign attorneys to courts and we call vicinages, venues. So I go to Mount Holly, for instance. Mark goes to Trenton and Plainfield. And the reason we send an attorney to a certain vicinage or court on a regular basis is for that reason, amongst others. We get to know the judge's favorite doctors, and that's one issue, and it ties in well with this issue of catastrophic claims. When we know what the judge or who the judge favors in terms of expertise in a bad concussion case or cervical spine issues, et cetera, we're going to make those recommendations to our client, and we already know in advance the judge is going to agree with our strategy and the procedure that we're taking to try and get the best outcome for the injured worker. We're in these cases. I mean, if someone's exaggerating, it's a soft tissue case. They've been a problematic employee from day one. That's different. These cases, we are trying to do the best as in our role to help the injured worker get the best possible result, because it helps everyone. It can reduce the wage loss, the medical, the eventual permanency, and you have a more fully recovered individual from what was a significant injury, because that should be everybody's goal. So again, in these cases, knowing your judge, knowing your venue is a big help, and that's why we send certain attorneys to these courts, as Mark said, because we know what judges or what doctors these judges prefer. So, and kind of dovetailing this, the second point in this PowerPoint, choosing the hired gun often does nothing but increase your costs and delay closure. And one of the things that frustrates me, and I know it frustrates Mark, when we're dealing with some of these big cases, and the file's already been given to us, and the second opinion was conducted, and it was conducted with a quote-unquote hired gun, it's not worth the paper it's written on. And it makes it more difficult for us to then go and get yet another expert, because the judge is going to say, you gave it a shot, and you gave it a bad shot. So please always feel free to reach out to us. Clients do on a regular basis ask us, who do we recommend? And when they come to me and they name a town, and I don't know the name of the town, because New Jersey's a pretty big state, I'll do a little Google map, but then I include all the attorneys that I know in our firm, our department, that work in that area, and ask them to get us the names of the experts they recommend. So we'll do that for you, and we do it on a daily basis pretty much. If getting the injured worker to the best expert is a distance, especially if it's just a 1 or 2 time evaluation, consider paying for transportation. Because if you get pushback from the attorney or from the petitioner because they have chronic pain, they've got a disability and a problem, and the thought of going hour and a half, 2 hours.
They can't make it.
Right. Consider paying for transportation if it's worth getting that expert opinion. Right. And another thing I always recommend is consider using what I say, boots on the ground. And by that I mean usually using a nurse case manager, and I prefer nurse case managers that are field case. I guess they call them FCNs, or field case managers, as opposed to telephonic. Telephonic can be okay in maybe a lower level case where you think there may be a significant exposure. Catastrophic cases, I like to see field case managers out there meeting with the injured worker, meeting with the doctors, and coordinating care.
Right, and you have the right as the authorizer of treatment to send out a nurse case manager. You do have to get the permission. The case manager has to get the permission if they want to talk to the petitioner, the injured worker, or not have contact with the injured worker. You do that through their attorney. But there is nothing prohibiting a nurse case manager to speak with the doctors, going over what's going on, making sure the doctor is aware of everything that's going on with that individual after an exam or any examination has taken place.
There's a famous case on this topic where the judge concluded that the efforts made by the field case manager, and she was paid for, she was outside of the carrier, she was an independent contractor, the services paid for her efforts were deemed subrogable. They were part of the subrogation lien. Normally it's wage loss, medical, and permanency, but they associated her efforts under the medical piece of the case in that medical bucket because the nature of the injuries were so, significant, and they crossed a number of medical fields, that her coordination of care amongst the various doctors was seen by the judge to be instrumental in the recovery of the injured worker. So that gives you an idea of how significant it can be to get these nurses out there to help us coordinate these cases. And we'll make the phone call from Jump Street. I'll call Petitioner's Counsel and say, this is a big case. If you truly want your client to get the best care, allow our nurse to be a part of this case. She's not being a watchdog. We're not trying to get over on your client. We all know this is a big case. The goal is to have the neurologist and the orthopedist and the cardiologist all on the same page to make sure that the medications are consistent, the diagnostic testing is getting scheduled,
appointments are scheduled,
etc.
Simple things like that.
So, and we as your attorneys, and you as the adjusters, to the adjusters that are out there listening, and to the self-insured employers or employers who have, carriers and TPAs working for you, it's too much to ask of the adjuster and the attorney to handle the medical piece of a catastrophic claim. So it's money well spent. So I certainly strongly recommend it. So I think this is just a little kind of a subtopic in terms of the using the nurse case manager. There are vendors out there, companies that you can engage a contract for, and they will take over the medical piece of your case, including negotiating contracts and pricing with the medical providers. They will review and summarize all the medical records. They'll streamline payment of the medical bills. In a catastrophic case, I've had a couple where an outside vendor has been retained, and they've been instrumental in getting the case on the right track. We're getting closer in one of my cases to maximum medical improvement in a catastrophic case that I don't think would have gotten there in another couple of years. So they've been huge. All right. So in terms of, once you've controlled the treatment, one issue that you can run into in the catastrophic claims is try and avoid letting the expert treat non-work-related conditions. And that's when your IMEs can sometimes come in handy, whether or not it's, more often than not, it's probably going to be in a psychiatric case, because when the psychiatrist is dealing with the petitioner, the injured worker, they're going to listen to all of the injured worker's complaints. And when you read the records in some of these cases, you see as the case goes further and further away from the date of injury, far more issues come into play that have nothing to do with the work-related injury.
We've seen it happen all the time where a lower back injury starts creeping up into the cervical spine, and you see the records and the doctor starts treating that. And where did this come from? So you want to, again, as Jeff said, keep it on track as to what is related to the accident and what is not. And if there is another problem that creeps up and there's a question, you may need to throw another expert in there to check it out and to find out or give you an opinion that something is not related.
I've been able to use IMEs successfully in reducing frequency of treatment and or the, I guess, the billing part of it by having this periodic examination maybe once every 6 months, and have the doctor number 2 advise that doctor number 1's treatment has become too repetitive or too frequent. And since you do control treatment under Section 15, you can use that IME to tell your primary authorized physician, your once-a-week visits are really no longer reasonable or necessary. According to our expert, once a month, once a quarter is all that's necessary. And you can start to control some of the billing, which has become out of control. Because when you read the records, oftentimes now family issues are coming into play that have nothing to do with the case. Siblings, parents passing away, becoming extremely ill, et cetera. And the focus of that recent evaluation has nothing to do with their chronic pain. Right. So you want to keep an eye on it and use your IMEs to try and control some of that exposure.
And the important thing about the New Jersey statute is we, as the insurance carrier defending this claim, have the right to set up an examination at any time as long as it's reasonable. So as long as you don't overdo it as far as getting a second opinion, the individual has to attend that examination. If they fail to attend, that could be a basis to actually cut off their benefits.
And if you make this decision to reduce what you feel is your appropriate responsibility for medication, frequency of treatment, et cetera, send that in a letter to the expert, to your expert, copy the petitioner so everybody's on the same page. They know if they go beyond that, you are simply not going to pay for it. And if they don't like your decision, it can go to court and the judge can decide. But if you've dotted your I's and crossed your T's, more often than not, the judge is going to agree that you've been appropriate in the way you've handled the case. So that's some of the recommendations we have with respect to the medical piece of these catastrophic claims. Mark's going to talk about the second benefit in New Jersey, or maybe some people consider it the first benefit in New Jersey, how to control your wage loss part of the case in a catastrophic loss.
All right. Yeah, as Jeff indicated, there are basically 3 benefits in workers' compensation. We've pretty much gone through medical care. The second benefit is wage loss, or temporary total disability benefits is what it's called. And this is what you receive when you're out of work under active authorized medical care and you're unable to work. The first thing to look at is how much are you entitled to. So that is based upon an individual's average weekly wage. What is the average weekly wage? It is the wage that someone received 26 weeks prior to the date of accident. So you would average out those 26 weeks. If somebody is salary, it's fairly straightforward. If they're a salaried employee, you basically break it down to a weekly amount as far as what their average weekly wage is. And according to the statute, the individual gets 70% of that average weekly wage, up to a maximum depending upon the year of the injury. And every year that maximum may change or will change based upon the statewide wages is basically what that's related to. There is that's the cap. There is also a minimum rate that someone is entitled to, and that again depends upon the year of the accident. So somebody could be earning $100 a week for a part-time job but they're unable to work anymore because of that. They will receive the minimum rate, which could be twice as much as that, depending upon the year of the accident. So you want to make sure you have all your wage information in place when you're determining how much someone is going to get.
And please do get that wage statement. I don't know how many cases that we get, but there's a nice percentage where there's no wage statement obtained, perhaps because the claims handler thinks that it's not going to be a lost time case. I have a case right now where we never paid lost time, but 6 months after the injury, the injured worker stopped working and has not worked since then. And so getting the wage statement, and I asked for it, but I haven't gotten it, and then eventually I got it, but it took a while to reproduce the records and the payroll. It's very important in this case because the exposure is so large, at least the petitioner thinks so. We did not, my adjuster did not think it was a big case initially, but he never went back to work. So they're like, wage statement? We didn't get one. There was no lost time. Get a wage statement in every case.
Right. And again, when you say 26 weeks, if they didn't work all the 26 weeks before then, you average it out based upon the number of weeks they worked. I had a note in there about overtime. You would include that in your calculation. Room and board, there's a mention of room and board. That's an individual, maybe a superintendent, where their pay is really nothing other than they get room and board. So there's a value that's put to that, and that'll be factored into what their average weekly wage is. It's important to note that you're entitled to temporary disability as long as you're under active medical care and the provider is saying that you're unable to work. Someone who finishes treatment, they're not actively treating anymore, are no longer entitled to temporary disability. That doesn't mean they're able to go back to work necessarily. They may still be unable to go back to work, but if they're not treating, they're not entitled to temporary disability anymore. There's oftentimes an issue as to what is active medical treatment. There's curative medical care, which is fairly straightforward. When you're treating and you're getting physical therapy, you need surgery or things like something substantial like that, that's pretty much curative medical care. There's a term that's thrown around a lot about palliative care, and there's oftentimes the mistaken belief that you're not entitled to temporary disability during palliative care. Palliative care, you really have to look at it on a case-by-case basis. If the palliative care is such that you need it to maintain your ability to function, and it's really necessary to get you back into the workforce, you could be entitled to temporary disability during that period of time. On the other hand, if it's not really necessary, you may need pain management or some kind of pain medication for the rest of your life, that may not be temporarily totally disabling. So then you're not entitled to temporary, and then you would move on to the next stage in workers and next benefit of workers' comp, which is permanent disability benefits.
Right, and this issue that Mark's talking about, I guess the point where curative treatment becomes really just maintenance care. So the palliative maintenance are very similar. Oftentimes they're one and the same. The mistake some of our clients make is they think that they're not responsible for palliative care. If the authorized doctors feel that the palliative care is necessary to maintain their functioning, and without the palliative care, their ability to function would therefore decrease and be limited, then the palliative care is going to be deemed reasonable and necessary. If it's going to keep them at that plateau of functioning, then the court's going to find that it's reasonable and necessary and needs to be provided. It doesn't have to be curative as long as it allows them to maintain, and without it, they would actually decompensate. But what we look for in some of these cases, and I've seen it in some, is temporary disability benefits are still being paid when I've gotten some files before and I realize they are no longer getting curative care. It is simply palliative. They need it, but it's not curative. So they have reached that plateau, and yet they're still receiving temporary total disability benefits. I've seen that a few times, and I've told the client, I know it seems strange, you've been doing this for 6 to 9 months, you've still been paying them. Stop their temporary total disability benefits. They're no longer receiving curative care. They have reached that plateau. Continue to provide the treatment, but end the temporary disability benefits. And what I've done in these cases of this magnitude is recommend that they seamlessly begin a voluntary payment of permanency. So the check may be lower because the permanency award might be a lower amount or lower rate, but seamlessly go right from temp to permanency, but stop the temporary disability checks, because they're no longer receiving curative care. They're not climbing that mountain anymore to get to the best that they're going to be. Right. They've climbed it and they've reached their peak. So now it's palliative. Flip them to permanency. So you're getting credit now for the permanency payments, but you're still getting credit in the court's eyes for providing that ongoing necessary treatment. So you won't be punished for doing so.
Right, and it softens the blow to the individual that their wages are just going to be simply cut off.
Right.
Now, there's other situations as far as while you're under active medical care, and you may have the ability to do certain things while under active medical care. The doctor says you can work, but under restrictions. You may not be able to lift as much as you can, or you can't bend as much, or you can't do work overhead. So there's a restricted duty. If that's the case, it's important, and many employers have this, they have limited duty available at the workplace. They have restricted duty policies in the workplace. That could reduce your costs significantly. And oftentimes we find, I think, that someone who goes back into the workplace, even though they may not be doing the same job, it seems to move along their treatment and the curative nature of treatment, when instead of just sitting around and not doing anything, they're getting back in the workplace. So if the doctor says you can do certain things, if there is work available, give it to them. It is the employer's obligation to find work, if that is the case, to put the person back to work. If there is no work available, obviously it can't be done. But if there is work available, you can require them to report to work. If they fail to do so, you can cut off temporary disability because it has been offered. We have a note up here about partial temporary disability benefits. There really isn't anything in the statute that says anything about temporary disability being partial. And what I mean by that is, if somebody's going back to restricted duty, but they're not earning as much as they were when they were working full duty, or they're not making as much as they would be getting if they were out on temporary disability. They're getting wages lower than the temporary rate. We talk in terms of partial temporary disability benefits. That can be done. There's actually a court case, I think, that says it's appropriate to do.
It's one judge level case. Respected judge. Judge Cox is a terrific judge. It's the only decision that's been rendered. It's not binding upon the other 50 or so other judges in the state. They're all well aware of it. The practitioners that practice workers' comp on a regular basis are aware of it, but nothing at the appellate level has been decided on the topic but for Judge Cox's decision.
So if you are faced with a partial temporary disability situation where you're going to consider that, the way you would do it is you would look at what the temporary rate is, take that with the net pay that the petitioner is receiving, net meaning after taxes and all from wages, and then make up the difference to make sure that the total payment is the rate that person would receive in temporary disability. Again, this is not a requirement, but it does make sense to do it because, again, it gets somebody back to work. It'll reduce your costs for temporary disability, and hopefully treatment will end sooner if somebody's getting back into the workforce and in the swing of things. I put a word here about vocational rehabilitation. In a very catastrophic claim, it's something you may want to consider doing and helping someone out to maybe find another job or train them into some kind of other type of work. And in this way, you're avoiding having to pay somebody total disability benefits, which again is benefits for the payments or for the rest of the individual's life. So again, there's something that to consider about vocational rehabilitation, even though it's not something that is required in the state in New Jersey.
And it can be helpful to defeat and contest the argument of total and permanent disability. Sometimes if the discussions are being held in chambers amongst the parties and the judge is considering finding totality, or petitioner's counsel is arguing for it, if you can prove through vocational efforts that there's jobs out there available for them, you can defeat totality. I've had a couple judges tell the injured worker's attorney to have their client refer to the Department of New Jersey's Department of Vocational Rehab to see if there's a job available. Right. And occasionally you have to try that issue in an odd lot doctrine type of case, which was just decided a month or two ago, and it's on our website. We reported about the case. I tried an odd lot doctrine case, and the odd lot doctrine is the petitioner has to prove that they have 75% partial total disability due to the work injury, and they make up the other 25% by proving that they're vocationally incapable of finding work, whether it's educational, language limitations, et cetera. So vocational can come into play in these catastrophic cases. And if it does, we're a good firm to go to, since we have so many attorneys that are very familiar with and experts in vocational rehabilitation, evidence and testimony. I did PA workers' comp for many years, so it helps to have that vocational, background.
We'll go on to the next. What we're going to talk about now is, again, a cost-saving and possibly a subrogation issue. It involves situations where an individual is injured as a result of some other entity's negligence, and that would give rise to a third-party claim. The injured worker has a potential lawsuit against whoever caused the injury or the accident. The third party obviously has to be someone different than the employer. You can't sue your employer in workers' compensation, but if the accident was caused by some other entity, for instance, if you're at a construction site accident where there may be subcontractors that created a hazardous condition and caused this accident to happen, there may be a lawsuit against that entity. You see this oftentimes when someone is injured in the course of driving in their employment and the accident is caused by the other driver. They'll have a third-party claim. So you want to look out for those things. You want to know if there is an issue as to whether or not another entity is involved. Maybe it's a cleaning service that didn't clean the surface of the floor properly in the place of employment, which is, again, a separate entity, and that person may have a lawsuit against that company that left the floor slippery, let's say. So you want to make sure that the claim is investigated, looked at as to who was responsible for causing the accident, and if there is a third-party entity. You want to assist the petitioner's attorney with that investigation, because they ultimately will be the ones that pursue that. Now, of course, a petitioner's attorney is going to be looking at that as well, because they know that there's claims out there, potential claims out there, and they're going to want to pursue that claim. If they do have a recovery from a third party, the workers' compensation can subrogate and will subrogate by statute against any monies and any recovery the person has against the third-party entity. And the recovery is generally 2/3 of whatever was paid out on a claim, if the recovery is sufficient enough to cover all the benefits that are paid out. And it could even be more. It's based upon the counsel fee that is paid in the third-party action.
So let's, in terms of the third-party cases, they are just, they're gifts, to the employer and the carrier. A lot of people look down on subrogation. I understand, because it's the injured worker who has the pain and suffering, et cetera. But until they change the law, we're taking advantage of Section 40 of the statute, which allows you to get, as Mark said, generally 2/3. It can be a little bit more, 2/3 of all the medical, temp, and permanency that you pay in a case. So, yeah, we want to have the evidence set aside, do the investigation that's necessary, and you can turn it over to the plaintiff's attorney when and if they ask, in terms of witnesses, statements, photographs, because it inures to your financial benefit to get some of the money back. And in these catastrophic cases, it can be a huge help, because if it's a big injury and there's negligence, there's oftentimes a big recovery. So,
and just so you know, is that if the petitioner doesn't pursue a claim, but you think there is something out there, and if they don't do that within 1 year after the accident, you as the insurance company and the workers' compensation respondent can pursue the claim on petitioner's behalf. Other concerns here is, in a catastrophic situation, is an individual, if the injury is that bad, can be entitled to permanent total disability benefits, not just partial disability, but total disability. Someone who's declared totally disabled as a result of a work accident essentially would receive permanent disability for the remainder of their lifetime. Generally what happens in a catastrophic situation is, and someone is in that situation, they're going to apply for Social Security disability. And the standard for getting Social Security disability is a little different than workers' comp total disability. Generally, it's a little easier to get Social Security disability as opposed to total disability and workers' comp, because Social Security will take other things into consideration in determining whether somebody is entitled to those benefits. But the important thing to know is that if you're totally disabled in comp and you receive Social Security disability, there are offsets that will be available to the workers' compensation carrier against the potential offsets against the benefit an individual gets in Social Security disability, which I'll get into a little bit later. How do we get to the total or what somebody is disabled? You set up permanency evaluations, both sides. The insurance carrier has their experts, petitioner has their experts. These doctors will examine the individual and render opinions as to whether or not or how seriously they're disabled. Now, just to step back for a minute on temporary disability, in a catastrophic situation, there is a limit on the amount of temporary disability benefits you can receive. The statute is 400 weeks. So if you're under active medical care, out of work, and again, you're entitled to temporary disability, that will end after 400 weeks. Now, that rarely happens in workers' comp, because if you're that bad, generally you're going to be declared totally disabled long before 400 weeks, which is almost 8 years.
If you're getting temp total and active curative medical treatment for 8 years, more than likely you're probably close to totally disabled.
Right. Again, the way permanent total disability payments are made by statute, the award is for 450 weeks as to the amount of weeks you get for a total disability award. And all that is one portion of the statute. Another part of the statute that triggers after 450 weeks says you are entitled to the continuation of those benefits as long as you remain totally disabled. So essentially, if you're going to be getting benefits that long and you're not going to be returning to work, there's very little chance that you're not going to be able to establish that you're still totally disabled. I have resolved claims for less than total, that's close to 450 weeks, and I will do that at times when, because it does give the insurance company the option or at least an argument to be made that after the benefits are paid out, that they're no worse than they were prior to when they were established partially totally disabled, maybe 70 or 75%. An individual during that time may get involved in another accident. And if that happens, that pretty much will take you as the insurance carrier off the hook for total disability benefits if something else happens to that individual that breaks the causal link of the disability related to the work injury and by the occurrence of a subsequent accident.
And sometimes surveillance will show them returning to work somewhere.
Yeah.
Even if it's on a part-time basis, but it's somewhat physically demanding. It gives us an option to get that Section 20 where you may not have had it if you just stipulated to total perm all by itself.
One consideration, again, is as it says here on the PowerPoint, is to make sure if there's individual is going to be declared totally disabled, that the order spells out what is the specific injuries that they're and medical conditions that render them totally disabled, because they may be suffering from other conditions that may be closely related. They think that might be related, but they aren't. So you want to make sure those things are out. If there's a question as to whether or not the neck injury is related to the back problems that the person is having or something to that effect, you make sure, again, you want to make sure those are ruled out. If necessary, you want to maybe enter into what we call a hybrid settlement. You Section 20 those kind of conditions out of the claim. You have it spelled out in an order, and this way that person can go treat for those other disputed injuries with whatever coverage they may have, which in most cases would be Medicare. If they're declared eligible for Social Security disability, they're going to become Medicare eligible within a year after they receive their benefits.
And it eliminates your exposure in the future for medical conditions that are questionably not work-related. You only want to pay for the future medical for those conditions that you agree and are clearly work-related. This is what I started out with, the catastrophic exposure discussion, that medical can be the biggest piece. Well, you want to carve out anything that's arguably not related and use whatever leverage you have, just accept that those portions of the case that are clearly related to your claim.
Right. Now, there's essentially two ways you can be declared totally disabled in workers' comp. One is that the obvious, where you have this traumatic injury, it's an accident, it's so bad that that accident in and of itself rendered the person totally disabled. Another way, and this involves what we call the second injury fund, is when you become totally disabled as a result of a combination of the work accident and pre-existing conditions. Now, those pre-existing conditions can be anything. They could be work-related accidents, non-work-related accidents. They could be illnesses that you're suffering from, like pulmonary conditions, heart conditions. You've had prior broken bones or prior back injuries or something. So it's got to be a combination of those two things that render you totally disabled. That invites the application of the second injury fund. And what happens in those situations is workers' comp will pay out their percentage of disability on the claim as to what is related to the work injury. And then after that runs out, then the second injury fund, which is a fund operated and paid for through the state, they pay the individual benefits from then on and for potentially the remainder of one's lifetime. So obviously this is a very big cost savings. And if you're in a situation like that, it all starts out with your medical investigation. You want to see and start lining up what may be pre-existing through an ISO claim search, where you see if someone else has had, or someone has had prior accidents in the past. You may need to subpoena those records. Certainly if they had prior workers' compensation claims where it's been adjudicated they had prior disabilities, you bring that in. You want to look at the treating records. Oftentimes the treating records will give the history of someone's pre-existing conditions that may be significant. So you're going to want to look at that. You may have to subpoena records from the family medical doctor or other doctors. Through discovery, you can obtain that information. And if you could put it together, and this is generally done by the petitioner's attorney, which obviously they want to look at this as well, because they're the ones that normally initiate the filing of a second injury fund petition declaring someone totally disabled. You want to assist them in getting those records, establishing that it's not the work accident that rendered the person totally disabled alone. It's a combination of the work accident and pre-existing conditions. Now, again, the way that would be paid out, and I said a little while ago, when you're declared totally disabled, the disability award is based upon a scale of 450 weeks. Now, in a second injury fund situation, what the workers' comp would pay is a percentage of 450 weeks. So if you can argue that the work injury caused 50% of the disability and 50% of it was pre-existing, then workers' compensation in that case would pay 50% of 450 weeks, or 225 weeks of benefits. Once that's paid out, that's the end of your obligation to provide any further permanent disability benefits, and then the second injury fund pays from there on going forward and beyond. Again, there may be offsets, as I said before, against Social Security disability. When you're under the age of 62 and you're declared totally disabled and you're on Social Security disability, the law says you're not entitled to receive more than 80% of your average current earnings as declared by Social Security and workers' comp. If there's an offset, workers' comp gets the offset against that 80% figure until that person turns age 62. So that's something you would be getting through the petitioner's attorney. They send to Social Security for that ACE figure, and you factor out, there's programs that Oscar is called in workers' compensation that'll do all the calculations for you to determine whether or not there's going to be an offset. Now,
New Jersey is only one of 11 states that gives the offset to workers' comp. So it's, while there's some disadvantages in New Jersey, that's one of the nice big advantages, especially in a catastrophic case.
Right. And again, that only applies if someone's declared totally disabled. If a person is only receiving partial total disability, they're not declared totally disabled, but they are on Social Security. If there's an offset, then Social Security gets the offset, no matter at what age.
Which is why sometimes we make a recommendation to push for or agree to a total disability claim with contribution from the second injury fund, knowing that financially you're going to get the huge benefit of the Social Security disability offset in a total case. Whereas if they're only partially disabled, you don't get the offset. Social Security takes the offset. So sometimes we sit there with a calculator and we hedge our bets a little bit or hold our nose and say, you know what, we're going to recommend that you agree to totality because it's far better for you financially.
Right. And it can be significant, those offsets. What are some of the concerns in a total disability and Social Security situation? Person is on Medicare. As you know, Medicare has become very aggressive about making sure that workers' compensation is not getting away from and having to pay for injuries and treatment that's related to the claim. That Medicare does not want to be paying for that. So you have to go through and make sure that there are no conditional payments through Medicare. On the flip side of that, if there are disputed injuries related to the claim, and you settle those claims out by way of Section 20, you may have to file for and obtain a Medicare set-aside in order to satisfy Medicare's concerns that you're not taking away and trying to force Medicare to pay for benefits that they're not supposed to be paying for. So that's, again, it's critical in a catastrophic situation is that you make sure, again, that the injuries that you're paying for are related to the claim. Anything that's disputed, you either have them ruled out by the court, which will then eliminate the need for any MSA for that matter, because the court said, oh, these conditions are not related. If there's a real dispute, you may have to Section 20 those claims. And if your settlement or that portion of the claim, and if the settlement is greater than $25,000, you're going to have to look into a Medicare set-aside and whether or not you have to put money up to cover that.
Yeah, so you pointed out one way to get around the future medical that's in dispute, and that's one, to have the judge rule it out. And if parties can often agree in chambers that the medical evidence is strong for the respondent, the judge can rule on the record that this part of the body is not related to the claim. And as a result, Medicare's interests have been taken into consideration, but there's no need to set aside future funds because the judge is ruling out that that left knee is related to the claim. So no money has to be set aside by the respondent. But the other way that you mentioned here in the PowerPoint to try and avoid exposure for future medical that's for treatments and conditions that are in dispute is to potentially have the judge rule that a certain condition, or the parties agree that a certain medical condition or disability is greater overall. And by that we mean that the back, the neck, or the knee has been injured subsequent to the work injury, and as a result, treatment going forward cannot be related back to the comp injury as opposed to the subsequent non-work-related event, whether it's a car accident, something that happened at home, etc. So again, those types of resolutions on a medical dispute would not necessarily involve, and would not involve, having to obtain an MSA.
Which can be quite costly at times, as we know.
Yeah, and that's what I was going to talk about next, is the obtaining the Medicare set-asides. They have become quite problematic, and they have prevented us from settling some of our cases, because we'll have a case settled under Section 20 for, let's say it's $20,000, which you would think is maybe under the threshold, but it's on a quote-unquote reopener. So the first time we paid 25% of the back for a surgery. This time we're trying to get out of the case, but you add the two settlements together and it's over 25 grand. They're now Medicare eligible, so the MSA comes into play because the total's over 25,000 and you're trying to eliminate your responsibility for future medical treatment to that part of the body. Sometimes those MSAs are coming back at 6 figures. So the case is settled for 20,000, but but the Medicare set-aside dollar figure for future medical is $100,000. It's becoming cost prohibitive. So what we recommend to you guys is have good vendors, have aggressive vendors that have a good relationship with Medicare that can present a good case on why X, Y, and Z dollars don't need to be presented. Why 3/4 of the treatment for the back would be due to non-work-related issues that all the doctors agree exist, but 25% of their back condition maybe is work-related. Have them try and negotiate an appropriate MSA. And if you can avoid the MSA entirely, then do that with some of the other suggestions that we had. One avenue and one strategy that's been employed recently is some of the vendors are doing reversionary MSAs where there's a certain dollar figure set aside, but they run that fund. So they pay the medical bills, they control the treatment, they engage in contracts with the vendors, but in doing so, they control the costs. And then when the person passes away, if they've set aside $100,000 that everybody agreed is appropriate and there's $50,000 left, the $50,000 comes back to the respondent. It just doesn't go into the estate of the injured worker. So it's an aggressive way to professionally administer an MSA.
Yeah, the professional administration of the MSA. Click the, sorry, the next slide. I think it was.
Yep.
There's when I just want to add about the professionally administered MSA. This has become a very popular way of dealing with MSAs. There are good companies out there. They make it very easy for the individual that has an MSA that people can treat with whoever doctors they want. The money is set aside for them, and they can get whatever treatment they want. They don't have to deal with workers' compensation in order to get authorization to see a doctor. And all the reporting requirements that are necessary back to Medicare is all taken care of professionally by that company. And for the carrier, the cost of that is very minimal, and it's well worth the expense.
All right, well, thank you, everybody, for joining us today. If you'd like to learn more about this program and the other programs that we offer, please go to our website, www.wglaw.com/WG-University. And if you go to that website, you'll see past webinars, podcasts that we're giving as well, not just in New Jersey workers' comp, but in Delaware and in Pennsylvania and other areas that we cover: general liability, employment litigation, trucking, et cetera. So check it out, and you can pick your favorite podcast or webinar. Thank you, and have a great day.
Thank you.